Redacción y negociación de contratos vinculados al derecho del entretenimiento. Pablo Máspero, Máspero Abogado.
Pablo Máspero Abogados, Argentina. Jamie Lieberman, #legal USA. Martín Moscoso, Consultant, Peru. Moderator, Aldo Fabricio Modica, Barreiro Modica Lawyers, Paraguay. Good morning, good afternoon, good evening, depending on where you are in the world. Welcome, everyone. This is the first ASIPI panel. This is a very interesting topic with interesting specialists about the drafting of legal contracts and the access to protected work through e-platforms that has been the way to basically use to consume content. The idea would be to restructure and reinvent our business model accordingly. Here we will deal with the basic concepts into the drafting and negotiation of entertainment agreements, especially in the music business. We'll talk about issues such as royalties, exploitation of IP, the image contract about content, advertising and marketing, organization of events, termination of contracts, etc. First, we will listen to Pablo, then Martin, and finally we will close with Jamie. I would like to introduce Pablo Máspero. He's an Argentinian lawyer. He is a professor at the university, at the UBA University of Palermo, University of Castilla-La Mancha. He is part of the staff of arbitration at the WIPO. He is the head of legal affairs for photograms and videograms. He's also, for many years, he's been part of the interpreters and producers staff. He has been part of the Argentine Chamber of Phonogram and Videogram Producers as well. Pablo, you have the floor. Thank you, Fabricio, for the presentation, and thank you. I would like to thank the organizers for inviting me to be a part of this panel and this event. Today, we have to talk about how to draft and negotiate entertainment agreements, and especially what has to do with the music industry. I was thinking of what could be interesting for you this afternoon to be able to see how we can enrich our work. I thought that I would tell you from my own experience what I think should be done and what I think should not be done. Firstly, I would like to suggest, playing around with the name of our panel, is that if we must talk about drafting and negotiation for the entertainment industry, even though this is a general concept, in the specific area of entertainment, it is essential to negotiate first and write later. Why? Because we all have a natural tendency to start to exchange draft and deal terms, and there was no previous clear, open, and deep conversation about what it is that we are drafting or agreeing on. I can assure you that in 90% of the cases, the parties did not understand the same. And this clearly shows that there is a need to have clear and transparent negotiation, not to waste time with endless exchanges. And if you are the lawyers or advisors of your clients, the first advice that we can give to those participating is first negotiate and then write. And to negotiate, it is essential to have our clients, to let our clients be part of the beginning of the negotiation from the beginning. And if the client, for some reasons, prefers to have the negotiation himself, and we as lawyers are simply drafters of whatever they agree, I think that this should be very clear to the client. And we should demand the client to provide specific information of what has been agreed and what has not. I can assure you that this that really sounds so obvious is not in practice. This is a common constant problem. And this happens even at the highest levels. And some people say that this happens only when they are not professional negotiations, but I can tell you that it happens at both ends, even of multinationals, because the parties understand what they want to understand. So, firstly, I think that we should negotiate first and write later. And when we negotiate, you shouldn't be shy to include everything. I mean, include everything you think should be included. They will come up at some point, and it's very important to have that as any negotiation. As in any negotiation, there are two main drivers. First is what our client wants, and then what our client is afraid of. What the client would like to happen or not. This happens in every negotiation, entertainment industry or not. And also we need to have very clear the legal knowledge about the agreement in the specific area. I think that those of you that work on it in the entertainment industry should understand the entertainment business and should understand that there are many issues, legal issues, that have nothing to do with entertainment, such as labor law. In pandemic times, this could be issues related to public health or to locations where the events could take place. And to consider all of these clauses that we used to include, for example, force majeure, that is something that we had not considered until now. And this year they have become essential in terms of, for example, when we're organizing a show that may or may not happen because of restrictions other than those of the parties. It is also absolutely essential to understand the business we're talking about, especially in my case, it would be the music industry. But this music industry is changing so fast, not only in legal aspects, because we know that the law always comes late, but the business itself changes so much, and the prices and the models and the way to calculate the payment of the different participants changes so much and so quickly that the only way that a lawyer or advisor can really collaborate with their client, of course, besides understanding their needs, what they want, what they're afraid of, is understanding the business. If you don't know the business in these rapidly changing times, then the pandemic has accelerated dramatically. We have had the changes in the last 6 months that we were expecting to happen in the next 3 or 4 years. So the music ecosystem has changed dramatically. Think of strictly the musical industry. The music industry has two main pillars. One of them is the exploitation of recorded content, and the other one that holds the ecosystem is the live events. This ecosystem that used to have two main pillars in these lockdown times have somehow changed, because one of the pillars, that is live shows, disappeared, and they have become smaller shows that do not cannot stand the strength of the industry. This disparity in the music ecosystem, because one of the pillars increased and the other one survived, have accelerated changes. That changed everything, because it changed, for example, compensation for actors or for one of the players. For example, one artist could see that the support that the content suppliers provided used to give, and then the artists could use in the live shows, and the authors were also benefited by the live shows. This already doesn't happen. So here we analyze the music industry from a pillar of the ecosystem that is not working. So how can we promote the other one? What is going on today in pandemic times, besides these general concepts that is first negotiate and then speak? If you negotiate from day one. If you don't negotiate, tell that to your client. Keep updated from the legal aspects as much as you can. Understand the business. That besides all of this, what I think should be of interest to you, that I think is important to discuss, is the phenomenon that we are experiencing right now, live streaming. If you want to see which is the business that has affected the industry dramatically, is this live streaming. With the only difference is that my talk here is boring, but fortunately I don't even dare to play an instrument. Imagine if you get bored with my talk, what it would be with me and an instrument. This is an example, live streaming, of how an agreement should be drafted and negotiated, especially in musical terms. Because my participation here was simple. I signed a release form authorizing my words to be used by ASIPI and be sent to everyone. But imagine that instead of me sitting here telling you what I'm telling you, it would be me interpreting a musical play in the same participation. it would be very different consideration. So if I ask you, instead of using the release form that Pablo, for example, signed for this presentation, what other contracts should we have? So the first thing that you should understand is this phenomenon. To understand how will this presentation take place? Will it just be live, or will it be available and recorded? And in that case, for how long? And the recording of this presentation, once recorded, will it necessarily belong to the organizer of the show? Because imagine, for example, if I am a music artist, and if I have a company that I have assured the rights to, I should be able to meet the commitment with this company and the commitment with the live streaming. And in this, along these lines, we should understand that if there is live streaming, I would not be probably playing music, but interpreting music from other authors or composers.
And for that, I'll need a permit and authorization to interpret them. And that will certainly be different because it involves another type of rights. If my presentation is recorded, because in one of the cases there would be a right just for mere communication to the public. Of course, there are nuances of streaming when the streaming is done, and in the other case, we assume that there are other rights involved. Now, as a lawyer, in order to know what are the rights involved, the first thing that I need to understand is what the business is like. When I was offered to be part of this talk of ASIPI, I knew what it was going to be. This would be, this session would be through streaming, and it will be in the platform of ASIPI for some time. This is a simple example because this is only words. And if they could be categorized as work, which is not, I would be the author of my work, and I would be the interpreter, and the audiovisual producer would be ASIPI. That is very simple. Imagine the same if I were to play the guitar and incorporate 5 musicians and play 20 songs from different authors and composers. If I had a contract with a record company, I would have to hire the musicians in the different countries, not just with intellectual right, but I would have to know the labor law. And so we go back to the beginning of the presentation. Before you draft any contracts, you need to negotiate. And so I need to understand the phenomenon that I'm going to be negotiating. The rest is more or less the same. What the client wants, to have the technical nuances of that apply to the contracts in this field, but especially, and with this I'll finish, you have to know the business. Thank you. Thank you, Pablo. This was very entertaining, very hands-on, and I assume that later on we will have time to specify things that may appear. Second, now Martin Moscoso, he's a lawyer who graduated in the Pontificia Universidad Católica of Peru, and who studied at the University of London. He has more than 15 years experience in the public administration. For 6 years, he was at the office, the Copyright Office, until February 2014, when he also chaired the committee for the Copyright Committee. And he has negotiated with the United States, with the European Union, and Trans-Pacific with Korea and China. He's professor of the course on ethical and ethics of the Catholic University of Peru. He has been worked for in WIPO, former president of the copyright and hosted in Geneva, and he has facilitated the work with for he has been a consultant of WIPO for Latin America. Well, thank you, Fabrizio, for your for your introduction. I want to thank the very kind invitation of ASIPI to be part of this panel. I feel very honored to share it with Pablo, whom I've known and admired for a long time, and with Jamie, whom I also express my greetings. So let us present some guidelines that will be further explained by you with regard to the audiovisual contracts. Indeed, there is a field of work that has to do with between the matter of contracts that that you are familiar with and the copyright, the PIRs. As an introduction, let me tell you that the audio-visual world is not only is it attractive and glamorous, but it also has multiple needs for setting rights and obligations of different stakeholders, and that enriches the need to be absolutely clear as to the scope of the obligations. So, out of all this set of potential contracts that are part of the audiovisual world, let me share with you a brief presentation where we will talk precisely about these contracts and these elements that need to be taken into account. So, on the basis of that, now you'll see it on the screen, the contracts for audiovisual work. Let me point out, first of all, that there are some basic assumptions that we need to use as a point of departure, and it is precisely that we need to understand what is the work that will be included in our contract. So, we have the definition of audiovisual work. Here, I put what our law establishes. It's an intellectual creation expressed through a number of associated images that give the sensation of movement with or without sound incorporated, and amenable to being projected or exhibited through adequate devices or through other means of communication of the image and sound. And indeed, as there are different potential platforms for exhibiting it, it is necessary to be absolutely clear about them and to study the issue before you contract each of the platforms. We're going to see that later on. The producer is a basic role. It's the person that has the initiative, the coordination, the responsibility about the production of the work. And it is absolutely essential to understand clearly who the producer is. I have a case now in the midst of the process where this notion of who the producer is being debated, because a co-production contract was signed, but at the same time, one of the parties thought that this was a contract of work that he was entrusted, but for some reason he signed a contract of co-production. So he was he didn't intend to be the co-producer. So the definition of who's the producer in the audiovisual realm is essential, because that person will benefit in the case of disputes, and also in the operation of the work. So the notion of producer is very important. Then we have definitions as videograms that are used and that are rather obsolete. This is when the audiovisual is incorporated in different devices, in video cassettes, etc. Then in some cases they say that the audiovisual work is a collective work where there are several authors under the initiative and coordination of one person. Usually it's a legal person that discloses and publishes under its name. So it must be clear of who is the author in the collective work. Usually, this is expressly included in the regulations, in the law in the region. What may vary, and this is a very important thing that needs to be taken into account, is who is the co-author of audiovisual work. Here, there is some variation. There is law where there is a basic set. In the Peruvian law, they include the director, the script writer, the person who adapted the work, if any, the author of a pre-existing work, if they consider that it's a derived work, the composer of the music, in the case of animation, the author of the animation. And that's absolutely relevant, because although there is it is assumed that the rights are yielded, and it is depending on who our client is, it is possible that we need different things if we were just to yield the rights. If I am the representative of the director or the script writer or the composer of the music created for this work, I'd be especially careful to have a contract where there is it won't be assumed, but the rights and obligations need to be coordinated. The higher the level or the prestige of the author that is included in the contract, either the script writer or the composer, etc., then the more will be the bargaining power, and the more clauses will be in favor of the artist. But that is not the case with young or novel artists that sometimes may find it more difficult to negotiate more beneficial clauses. Now, in the case of the director, we need to consider the following. In the legislation where there is a presumption of the yielding the rights, it is better to do that than to have a bad contract, because if you decide to sign a contract and it is poorly drafted or not drafted enough, if they haven't defined the rights, the platforms, or all the elements that need to be included to be absolutely clear as to who has the copyright, then you're going to have surprises. While if you do it in a complete way, that will be of benefit. I would say that the producer, knowing clearly that they are benefiting of a presumption, would be in a better position than all these authors that would be interested in signing a contract if they don't want to lose the rights that they expected to be able to maintain under their ownership. So we said that the producer is, of course, not the one that appears with the role as the head of production, but as we pointed out, it's the person that has the initiative of for doing the job. Very often, it's a person that proposes doing an audiovisual work. While in countries where the audiovisual industry is not so developed, we see that sometimes the producer is the director, it's the creator, it's his opera prima, and this person wants to be everything, and so sometimes that those people turn into production. So these are companies that are related to the directors, essentially the directors that, as you may know, are co-authors of the work. Here, the roles are merged. And but insofar as the audiovisual sector gets developed, the roles are more distinct, more clearly. So the producer will look for script writers and authors, and will select the different roles, and the contracts signed will become more relevant in each of those cases. That is why I said, and here this is the assumption imported from the copyright, is that it is assumed that the producer has all the rights of use exclusively for the time that these rights are valid. So we have pointed out that this needs to be taken into account for the benefit of the producer. However, there's something that I need to mention, especially in the countries where we have the continental system, that is the presence and the importance of the moral rights. Knowing that the moral rights, specifically in the audiovisual industry, especially from the perspective of copyright, have a minor incidence. They're not as important, whereas in the continental system, these are more relevant, and here we must consider that the director may exert those rights, and this is essentially expressed in the credits. This is something that is negotiated very carefully through all the value chain. They define how the credits will be mentioned. And as the work is circulating in different countries, transnationally, you need to be aware how to treat the moral rights that will depend on the fact that it will circulate in different markets, so as not to have any problems with the countries that are more stringent in the case of the mentions of authorship. You already know the moral rights. We won't repeat them. Paternity and integrity are basically the ones that are mentioned in the free trade agreements. These are the most frequently discussed, more than the others in the list, such as, Peru, for instance, adds modification, variation, and withdrawal of the work from the market and access. The FTA with the United States that many countries have done and that I participated, it is common to assume even to leave the moral rights out. So behind this, you have there is the concern that it shouldn't affect the normal use of the audiovisual work, so that they can exploit the work, including the new technologies. And the list of the asset rights the network rights, where you have to express which are the rights that are yielded. There are also common clauses that are part of all the contracts that we will see. A typical one is that of conflict resolution. That is a relevant thing to see whether you're going to use alternative mechanisms for conflict resolution. Sometimes you don't have these clauses, and then you accept going to an arbitrage in New York, for instance, or in California, and not necessarily is that what you thought, or that you were ready or you had a budget to accept. So you need to be very careful when you go through the common clauses that usually include alternative mechanisms. The preferred one is typically arbitrage to negotiate, where the conflict resolution will take place. Common clauses of termination of the contract. These are also established in all the contracts used in audiovisual terms, because sometimes because of non-compliance with infringement by one of the parties. But the important is not to have the clause of termination, but the consequences of termination. And this is very relevant, because in the termination clauses are relatively standard. However, the consequences is quite a relevant issue, because very often, as a result of the termination, there are some expectations, particularly economic, that may affect our contractual our contracts. So much so that sometimes they even mention expressly the interest that some previous contractors had, where there was a termination of the contract, but they remained with some rights, such as recovery of economic costs or preference on some rights. So that although termination clauses are standard, we have to be very careful about these things.
The territories as well. We should assume that territories are easy to determine, because it's easy to know where the audiovisual work will be exploited. But this is not necessarily the case, because it's important to clearly think how we can choose the territories, because the production works benefit from funding from sometimes state sector, especially from culture that they provide. In the case that there is a specific origin identified or nationality identified to the production itself. So we should clearly determine what is the origin of the production, so as not to lose the funding needed that we could have obtained in pre-production. Also, exploitation is important, because exploitation has to do with a specific kind of funding. If you want to enter the US market, not only to the United States, but also Canada, or even sometimes Mexico, you will have certain demands of exclusivity to trade your work in the North American territory. And if you have subscribed with co-production companies beforehand, there will not be restrictions or geographical areas that would be excluded from the exploitation possibility, or to share benefits. So, and maybe we find a problem, because if you are going to allocate revenues to some sectors and there is not enough money to cover the production, and it comes to relevant territories, we find players that will require exclusivity. So the issue of the territory is important, and it should provide a previous solution to this problem, so as to be able to achieve possible funding and to meet the needs of those that have trusted us such as the financiers or the lenders, those that don't participate in the works but simply want a return for their money. So if we adapt the work, that means this is a way of carrying out audiovisual work, that is to find the literary work that have been already successful, or works that we know have already had an impact in the audience, in the potential audience. Then we require the adaptation rights to the novelist, if it's a novel, or to the cartoonist, if it's the case of cartoons. But in that case, the authorization from the author should have two pillars. One is the rights, and the other is the copyright, and the other is the authorization. You know that the license on the copyright enables certain uses, but to cede the rights involves further rights. If there is a pre-existing agreement, it will not be easy to have an agreement that is not a license. The important thing here is to try to achieve exclusivity, or to develop a different different kind of contracts that would be an optional contract that separates exclusivity with possibility for a specific term that could be 1 or 2 years. This is an option. It's an option agreement to carry out a work based on, for example, a previous novel. This enables us to find funding that is not something that could be done in every case. So this option agreement does not necessarily carry out the final work, because not everybody obtains complete funding for a movie, for example, at the beginning. And this is why many of these option agreements terminate beforehand. And that's why it's important to include a clause for renegotiating this option agreement, or even the possibility of obtaining preeminent subscriptions. This type of agreement, the option agreement, is quite interesting, because the industry invites us to not just to have a simple agreement to have exclusivity to carry out this work in the future. This agreement already includes the terms and conditions already negotiated, so that the rights are conveyed beforehand, so that the contractual agreement terms are already negotiated in the agreement. So the possibility of moving from the option to the implementation of the agreement is already included in the option agreement. And this makes it easier to carry out the work. And the problem then is what happens in the case that the work is not carried out. And in that case, the suggestion is to include a clause that considers the possibility of recovering the costs, or returning or refunding costs in case of risk of one of the parties, or even of the writer. You know that when an adaptation happens, the work is not necessarily translated from the novel, for example, into the film. That requires a third novelist or a third writer that would adapt the novel to the movie. So that is a different kind of writing from the novels. So when this new agent participates, sometimes the original author would like to review this translation, so that so as to make sure that his or her rights are respected and that the original novel is respected. So what happens then is that the original writers sometimes become co-drafters of the second draft of the novel that is becoming a script, or they become sometimes co-drafters of the script itself. So they are the ones that cede these rights. So when the script is created, we have to be careful to include these moral integrity rights, and that the authors should participate, so that when we make sure that when the script is finished, the author will accept it. And if they don't, then our final work could be blocked if the authors consider that their rights are not respected. So it's always a good idea to make them a part of the narrating process. However, if the script is original, it's easier, because here we have one author that is writing a script directly. So the legal framework is already easier because it's not pre-existing work. And then the author could could write the script, and the lawyer could include in the agreement all the necessary provisions so as to include all the rights of the universal territory with a limited deadline, etc. So in these cases, in the case of an original script, there is possibility of having less surprises because the script didn't exist before. It just existed because of the project. Sorry, Martin, but you have to round up your idea because we are running out of time. I think that this license and session dichotomy is essential, because you should know that the main success of a production is to exploit all possible platforms. That means not only to exhibit the work at the movies, but also to show it on TV, open TV, internet, cable TV. So all of these exploitation modalities provide possibilities for funding. So we should be able to separate the different exploitation means so as to exploit the benefits with our partners, and not to affect the possibility of obtaining additional funding once the works have started, especially for audiovisual work. I would also like to say that besides these contracts in the creative part, there are exploitation agreements. These agreements have to do basically with distribution, and there we have distribution agreements and territorial agreements. But as we know, those agreements are standardized and that they have major distributors, and there is not much possibility of negotiation in that respect. In markets such as ours, where the distribution is not very developed and emerging and growing, it is still possible to negotiate the distribution of these works, especially in what has to do with cost setting and the profitability of the revenue, so we can have a clear idea of cost, revenues, and participation or share. So that would be the end of my presentation. I'm happy to hear your questions now, or to receive your questions now or later, as you wish. Thank you. Thank you, Martin. Yes, we do have a lot of questions, but we will leave that for the last session. And finally, last but not least, We have Jamie Lieberman. She's the owner and founder of #Legal, and she's worked there for over 15 years. As an entrepreneur, she understands the unique needs of the business owners in her organization, and she now partners with clients from different sectors, including influencers and e-commerce. She has the commitment to make the legal framework accessible and the business concepts available to everyone. And as an expert, and she has also participated as a co-presenter in podcasts.
Please go ahead, Jamie.
Yep. Thank you so much. I'm so happy to be here. I'm honored to be a part of this great panel. And I'm here today to talk about influencer marketing. So drafting and negotiating entertainment agreements from the perspective of influencer marketing is a little bit different than what we've heard, but I think it's an important thing. A little bit about myself. I have run a law firm in the United States called #Legal, and I've worked in the influencer marketing industry for the last 7 or 8 years before the term influencer was even used and individuals were just creating content. So I've seen the drastic changes in the industry. It's much newer than many of the other industries you've heard about. I'm also on the board of directors of a nonprofit organization called the Influencer Marketing Association, which is committed to the ethics of influencer marketing. So many of you may be asking, why are we even talking about influencer marketing? It's such a new field, not many people get into it. And so I want to talk a little bit about the framework of influencer marketing so we have a better understanding of drafting and negotiating contracts that will be relevant for all the parties involved. Influencer marketing is growing drastically every year. It was an $8 billion industry last year. It's projected to be over $20 billion by next year, and it is not going to go away. So having an understanding as an attorneys in the entertainment space is really important. It is very different. I also practice in the areas of music and audiovisual and other talent areas, but influencer marketing is very unique. So understanding a little bit about why individuals use influencer marketing is helpful for those contracts. Influencer marketing is not like traditional advertising. It does not typically drive sales. Instead, it really is driving messaging and awareness around either a brand or a specific type of a product or launch. Influencers obviously have control over the communities with which they work with. And so often a good influencer who's giving some kind of sponsorship or an ambassadorship around a product is really, really helpful in gaining trust and giving information out to a good target market. So understanding what influencer marketing is and why it's important is helpful in understanding the legal considerations. So I'm going to touch on the relevant parties, the relevant contractual provisions, and I also, from the United States perspective, I'm going to touch on FTC disclosures. This is a really important part of the legal considerations. Understanding not everybody is in the United States, but I'll touch on why it's relevant to people who are even outside of the United States. So the parties. So the different parties that you may be considered when you're looking at an influencer marketing contract are going to be the influencer themselves. That's usually the individual who either has a website or a YouTube channel, an Instagram account, TikTok, you name it, it's always changing. But the influencer is the person who's talking directly to a specific community. And those influencers can range in another of types of influencers. You have your mega influencers, your celebrities. Unfortunately, I'm going to have to mention the Kardashians because they are the ultimate celebrity influencer, but they're a great example of someone with wide reach, but perhaps they are not as engaged with their audience. And then it tiers down from macro influencers who might have 100,000 to 1 million followers, mid-tier 50 to 100,000, macro 10 to 50, and then nano influencers 1 to 10,000. These Definitions change all the time. There are not many standards in the influencer marketing space, but this gives a general framework about how people approach these types of deals. And different level of influencer will get a different type of deal, and they'll be paid differently, which we'll talk about. The other two types of parties you're going to encounter are going to be brands, who are the individuals looking to connect directly with influencers to get the messaging out. Those brands have different responsibility than influencers, and the brands, if you represent brands, tend to be more interested in the FTC disclosures because right now they're the ones who are typically on the hook a little bit more than the influencers. So there's brands, and then there's the middleman, the agencies. And you have agencies which are marketing and PR agencies usually, and sometimes they're talent agencies because as influencer marketing gets larger, it is starting to blur lines with talent agencies. And so I now have clients who are setting up talent agencies specific for representing influencers. Typically speaking, marketing or branding agencies are representing the brands, and they are connecting the brands with the influencers and being the middleman. So there's going to be different contractual considerations depending on who you represent. In my practice, I work with all three parties, so I have a good idea of what each side is looking at and how those deals are structured. So the important thing to remember, though, when you're structuring those deals is the different interests. So sort of bear that in mind as I talk about these examples of different types of influencer marketing deals. So when a brand is going to approach an influencer, or frankly, an influencers often pitch brands to try to get these deals, they're looking for, generally speaking, one of these types of deals. Affiliate deals are pure commission-based. So you're going to post about a particular product, and the influencer is going to make a specific commission based on the number of sales made. This is probably the easiest deal to enter into. They are typically straight up standard terms and conditions. Occasionally for higher dollar amounts, you will have some more negotiated deals, but for the most part, a brand will have an affiliate program. The influencer will apply, they will be accepted. There are also hybrid deals, which I'll talk about. The most common, and the second that comes after that, are sponsored content deals. A brand comes to an influencer and says, we want you to create a certain amount of sponsored content that's going to appear on the influencer's channels. So the influencer, and I'm going to get to specific contract provisions, but typically speaking, the influencer owns the content that's created and then will share a license with the brand for a certain amount of time or not, depending on how well the brand will negotiate it, for a certain type of display. And obviously, as I said, there are differing interests. The brands want to get as much of that intellectual property as they can give, and the influencers want to keep as much as they can because they want to be paid for those types of uses. Sponsored content deals, they're typically short-term, 1 or 2 posts. They last maybe a month or so. They're not necessarily a long-term experience, and they usually revolve around a product launch of some kind or a new brand launching. These are easier. They tend to be, they can be very high dollar amounts. I've had clients who have paid $50,000 to $100,000 for a single TikTok from a mega influencer. So it isn't to say that sponsored content deals can't be high dollar amounts for a very short video that doesn't take very long to create. But for the most part, sponsored content deals are the simpler. The ambassadorships is another example. Ambassadorships are more long-term. They are tend to be lasting at least 6 months to a year, give or take. And those are going to be more exclusive relationships. So likely you'll have exclusivity provisions, non-compete provisions in those ambassadorships. So that's something to think about. And it will be a long-term relationship of many posts over the course of many, many months, if not a year. Sometimes brands will look for social media takeovers. This is really interesting from the brand perspective because often you want to worry about, in these types, morality clauses, which I'll touch on, because if you have somebody take over your social media, meaning the influencer will essentially log into the brand's, say, Instagram account and then just post something about their day or somehow related to, this is designed to be able to get the influencer's followers following the social media account of the brand. It is important to note behavior is really important here, particularly for the brands who have concerns about ethics or morality. Some brands don't care about that, but many do. You also have direct content creation, which is when the brand owns, it's a work for hire, which I'll touch on. You have spokesperson deals where it is like a true talent agreement at this point, and certainly many influencers are spokespeople. And then you have the deals where an influencer may have created content. This happens a lot on YouTube, and a brand will reach out and ask to license that content for a specific reason. For example, I have a client who created this YouTube video, and a very famous makeup brand wanted to use it in one of their commercials. So she doesn't have to do anything absent enter into a licensing agreement. So we were really negotiating a pure licensing agreement. So the types of contractual provisions that are going to be important. I've listed a whole bunch, but I want to make clear I'm going to touch on these as best as I can. I am absolutely happy to answer questions as well. Representations and warranties are going to be really important, and they are going to depend on who you represent, how you're going to more heavily weigh them. With influencers, you want to make sure if you represent the brand that the influencer is repping and warranting that they're creating original work. And you also have to be concerned about the use of subcontractors. Influencers use subcontractors all the time, and unfortunately, they don't often enter into good agreements with their subcontractors. So as an attorney representing a brand, you need to make sure that your influencer has good contracts with his subcontractors, so there's never an issue down the road of who is the owner of the content that was created. On the influencer side of things with brands, the influencer, if you represent the influencer, has to be concerned about the use of brand intellectual property. That's really important to make sure that the brand owns the intellectual property and the materials that are providing. Brands will not only provide trademarks or logos, but they'll also provide assets, as we call them, which are marketing materials. And so as the influencer, you want to make sure that when you're posting that asset, you're not going to get a cease and desist later because the brand didn't have the rights to allow you to post it. There's also issues with advertising claims, particularly in the case of products. This is incredibly important from the influencer side and frankly from the brand side, because there's case law in the United States where influencers were actually sued. They got caught up in the middle of two energy drinks suing each other over products liability. One of the energy drinks had hired a number of influencers to post on their behalf. And then unfortunately, with these products liability claims, those influencers got sued based on the claims that the brand had given them about their products. And so influencers have no way of checking these product claims. So it's really important to include a rep and a warranty around those product claims and also an indemnification clause. Thankfully, in that case, many of those influencers did have indemnification, so the brand was able to step in. Payment is another thing to think about. The brands want to pay at the end, the influencers want to get paid up front. So when we're negotiating this is obviously, we have differing reasons why. Unfortunately, influencers often don't get paid. And unfortunately, in the brand case, influencers don't create what they're supposed to create. So you have kind of a tension between the two. And so oftentimes, they're usually done on a flat fee basis. Where there's just a certain amount of deliverables. The scope of those deliverables I'll just touch on it now. I do have it listed at the end, are critical to the influencer marketing contract for both sides. And the reason that is because you can easily exceed scope from both ends. In the deliverables, it's not only important to include one Instagram post, one blog post, and maybe 5 Instagram stories, but you also want to include the number of revisions, whether or not the brand is able to review drafts. You want to make sure that you include what type of revisions are allowed, whether it's completely revising something or if there's a reshoot fee. So really articulating the deliverables will be really important to making sure we don't exceed scope. Flat fee is usually there, like I mentioned before, you can have an affiliate relationship. And if that's the case, you want to make sure that there's language in there that gives the influencer auditing rights to make sure they're being paid correctly and that they're able to get paid the commissions that they're due. and how that's tracked, whether it's through an affiliate marketing system, through a specific link, through a specific code word that has to be given by clients. Flat fees, I mean, most influencers are asking for at least something up front, whether it's some kind of deposit and then payment on the end. One really important part of payment from the influencer side is not releasing the intellectual property rights until the receipt of full payment. So if you've turned over all of your intellectual property rights as an influencer, you want to make sure that they can't use it until they've actually paid you. So that's really critical. And obviously brands, they don't want that in there. So it is important to reconcile those. Intellectual property ownership is important too. Most influencers these days will not create works for hire unless you're willing to pay more. So just knowing that if you are asking for a work for hire, which in the United States means that the entity that's commissioning the work is the sole owner of that work, it's just important that you, one, use those words if that's what you want in your contract, because that's required, but also that the influencer is going to be asked to be paid more for that. So just knowing that in the negotiation, most of the time the influencer retains ownership, but usually will grant some kind of exclusive license to the brand for a certain amount of time, for a certain amount of scope. Brands obviously want the broadest license of possible. They want derivative works. They want to be able to display, publicly perform all the different copyright rights. And that's a really good area for negotiation on both sides. Exclusivity is another area that is often negotiated and is important to consider and important to define correctly. When we're talking about what exclusivity looks like, it's usually the brand telling the influencer, you're not permitted to work with any of our competitors, or you're not created for a certain amount of time. And so clearly defining who and what a competitor is very important. I had a case a couple of years ago where the exclusivity clause said breakfast foods, and we had quite an argument about what a breakfast food is. There were some analogies to pizza being breakfast foods in the United States. And so we can certainly make those arguments. So keeping those exclusivity clauses narrowly tailored so that there's no confusion, often listing specific competitors that the influencer is not permitted to work with is very helpful. Analytics is another clause. It is industry standard that an influencer will provide certain analytics about their posts that they can get from the different social media platforms and their websites. Some influencers push back on this, and so the brands want this. And so this is really important to include and to make it clear, because if you don't include it, you can have an argument. And we did have an argument with a client who I represented the brand. It was not included. And they pushed back. We got it eventually, but it's just not a fight that you want to have. Termination is also important in these contracts, depending on the length of the contract. Many brands want to have the ability to terminate at any time. And particularly if you represent an agency, because sometimes agencies lose clients, and sometimes agencies also have they change direction. And so if they're changing the direction, the agency wants more flexibility. So oftentimes influencers will negotiate what we call a kill fee, or a certain amount of money where they'll keep the deposit if for some reason they've started work, or payment pro rata. You can also just do termination for cause or without cause is another way that you can do that. And that's also another negotiable point. Morality clauses are another great example. These really come into play with talent agreements, ambassadorship, sponsorship agreements. So those are critical as well. So it is important that if your client as the brand has certain ethical guidelines and doesn't want certain posts, because there's lots of different influencers out there doing lots of different types of content, that it's very clear what that morality clause looks like. And it's also important that that morality clause is defined clearly. General morality clauses are hard to enforce, and frankly, they're confusing because what's morality to me may be different than morality to somebody else. So those are some examples of contractual provisions. I know I discussed FTC disclosures. I'm going to touch on them briefly next before I close out and give people an opportunity to ask questions. So FTC disclosures. So lots of people, particularly those who are not in the United States, they say, why do I even care about this? The FTC in the United States, the Federal Trade Commission, they care about any posts or content that is reasonably foreseeable that will affect you as consumers. So if you are targeting with your brand or your client is an influencer and they are targeting US consumers, even if that individual or the brand is not sitting in the United States, it is a best practice and a very good idea to comply with the FTC disclosures. The FTC disclosures are the social media disclosures. They're found on the FTC's website, which is a governmental organization in the United States. And basically what they say is influencers must disclose material connections clearly and conspicuously. So what does that really mean in plain English? It means that anywhere that you have a material connection, which is monetary, employment, family, if there's a trade, so if we're trading services, I had a client, for example, who a brand gave her a brand new kitchen that was worth $50,000 US. So she didn't get any money, but she got a brand new kitchen for $50,000. So that trade still is monetary. And even if there's personal investments. So it is important, particularly if you have if you represent a brand who has their employees posting about the brand, the FTC requires those disclosures. And where is it? It's anywhere that they're talking about the relationship. So it can be blog posts, social media, and different social media channels have different disclosure requirements. So for example, Instagram stories, because there's no caption, it would need to be on the image. In YouTube, you need it both in the description and also you want to say it multiple times in your video, depending on how long it is. It's just really important that it's clear and conspicuous. There are no set standards absent. It must be, I like to look at it as it must be clear to pretty much anybody who's looking at it, whether they're technologically or social media savvy. So in a blog post, it has to be before the clickable link, or even in a social media post. So if you are tagging a brand, you want to make sure that before the user clicks that link to tag the brand, you've disclosed your material connection. You also can't bury it in hashtags. So when you see, if you look on social media and you see those massive paragraphs of hashtags, you can't bury a hashtag ad or a hashtag sponsored in there. It has to be separate so that it's easy to see. You can also use plain language, but that plain language has to be clear. So it's important that you at least take a look, if you do have a client who's coming into the United States, to target US consumers. And now I want to leave time for all of the questions, because I'm sure lots of people have questions. So thank you for listening.
Muchas gracias, Jamie. La verdad que muy interesante.
Thank you, Jamie. That was really very interesting indeed. We have some questions. If you want to, you can write them down. The first question that we have, I think that it was during Pablo's talk, but it's also related to the rest. Among what you mentioned about the non-contractual execution the failure to comply because of the pandemic, have you seen an increase in litigations in the pandemic, especially the trans-border infringements? Can you hear? Indeed, the pandemic, well, that I know of, there haven't been litigations that have reached court or arbitrage, but there has been renegotiation of all the contracts, the shows, the contracts, the audiovisual and the music contracts had to be renegotiated. In the music industry, it is very common to establish that if a show cannot be performed because of force majeure, it will be reprogrammed. Because especially for the live shows, there's a tradition in force majeure, because the artist may get sick, or they may not get a visa, or the plane gets late. So force majeure is usually included. Now, the rescheduling, because of the long length of this pandemic, have become extremely complex. So there have been many cancellations. with the difficulties of returning the money. We haven't seen the problem so much in Latin America, but I have seen that in particular in the United States and then in the UK, there were many lawsuits discussing the what was understood by force majeure, including whether a pandemic was included. There was, for instance, one case in the UK against a standard definition in the insurance that because the insurance company claimed that a pandemic was not a reason of force majeure, while the organizers believed that it could. They tried to renegotiate it, but the lengthening of the pandemic determines that many reschedulings won't be possible, and many of them may end up in court. If I may, let me point out that in the audiovisual industry, it's also been the case, as a similar thing has happened. That is, because of the impact of the pandemic and its repercussions, for instance, restrictions to go out and film or use shooting and locations, and even people who are vulnerable because of the age, people who cannot move as others. Because of this, there has been postponement of the dates of production, essentially at the production stage, although in some cases too, in the pre-production stages, there have also been problems because of the mobility restrictions. So this has had an effect in the renegotiation of the co-production contracts, because these contracts established the dates, the deadlines for completing certain things. For instance, complete funding or the premiere of the work. So the difficulty here of these renegotiations is that normally you may be certain about what's going to happen, and so you propose postponement, but for months it's been absolutely uncertain what will happen, because for instance, now the health measures of the lockouts have been extended by 30 days and then additional 30 days, etc. So the main difficulty has been not to have clear deadlines. That has led to the cancellation of many shows.
Not because of lack of determination, but because of lack of predictability for the new conditions. So right now that we are seeing some light at the end of the tunnel, because of the possibility of having the vaccines, maybe we can reconsider now the fact that the agreements could be redrafted in a way that these additional costs can be negotiated and reallocated so that they could be included in the budgets. This could generate additional pressure for new funding, and that comes from new players. And this will definitely generate not necessarily new litigations, but because we all want the project to happen. So in this case, the litigation comes from the differences from the stage of the renegotiation itself. Anything you would like to say, Jamie?
Yes, there hasn't been too much litigation yet. There's been a lot of litigation in the United States around the pandemic, for sure. Specific to the influencer marketing, it's mostly been renegotiation of contracts. The contracts don't tend to be large enough to merit litigation immediately, although they do certainly get there for some of the larger ones. But for the most part, it's been renegotiations, a lot of which is because marketing budgets have changed and brands have changed and their messaging has changed. So there's certainly been a number of individuals who either haven't been paid or who are changing their messaging in such a way to be more understanding of what's going on with the pandemic, so it doesn't feel tone deaf.
Muchas gracias. Otra pregunta dice, ¿cuáles son las pautas más comunes a la hora de establecer?
Another question talks about the most common guidelines for renegotiation in the new industries. I think that Jamie already talked about this, but I would like to hear Pablo's and Martin's opinion about this. Before speaking of royalties, I think that it would be important to say that the main issue here is the price or the compensation obtained from a certain player. So when we talk about contributions that or payments for activities that we consider to be creative, we open the possibility that the compensation could be a royalty. What do we understand as royalty? Royalty would be a percentage compensation calculated on a certain basis. Not everyone who makes creative contributions have the right to royalties. For example, sometimes the musicians are always paid through a flat fee, but the main actor or artist sometimes does get royalties. It really very much depends on the creative importance of the player, especially for musicians that sometimes started to be paid through a flat fee. Then they started to have percentual compensation. And in terms of the royalty market, yes, this is constant because the business models change. Therefore, the royalties that could have been agreed for a specific type of business have to be renegotiated to see if they are still fair. My advice to all of you when you are about to negotiate royalties, to please consider the percentage of the royalty, yes, but most importantly, check the calculation base for that royalty, because sometimes a figure that looks good, if it's calculated on a calculation base that has several discounts or is a net base, then you really need to know the business so as to really be able to calculate what that percentage represents, especially when you are comparing offers, because sometimes we are comparing apples and peaches here, so it really doesn't work. You have to compare apples and apples, and you really need to consider the percentage, the calculation base, and to see what that really means. Thank you. Martin, yes, it's always a recurrent question, because in most of our countries, this market freedom that we have sometimes, when we are free to fix the rates, then there is a wide range of options based on the different conditions. If it's a first time work, it will be different from one that is not. Sometimes participants, instead of asking for a flat fee, they ask to share the fee and to share the risks somehow. This is being used more and more often, and they will require a percentage of the profits made. But we need to keep in mind that some of the parties will require the complete payment, such as the banks, that they will require their percentage. And we also need to consider the payment to the distributors, that they will require immediate payment as well. And then after the distributors, you have the other participants in IP, and the authors are the ones that have a higher share in the participation. So sometimes when it's a first time work, we don't offer the previous payment, and unless they have moderate chances of success, in which case we set a fixed payment and then the payment of different percentages, so that we are free to offer the creative service and then depend on the success that the movie, for example, could have. And then there is a possibility of setting ranges. For example, if you reach a certain number of viewers, for example, or people in the audience, you get a certain percentage or a higher percentage, so that the revenues then depend on the audience. I can tell you that I can tell the lawyers here that in my experience, even the legal advice office can obtain a fixed payment, and we as legal advice can also share these risks. We can share the percentages of the risk. And this, of course, is riskier, but it generates trust with the client, and we can have higher returns depending on the talents. Remember that the audiovisual industry is never 100% successful. There's a quote that says that in order to produce a certain number of successes, we should produce a certain number of failures. These are not really failures, these are trials that make the success possible. And we need to take these premises in mind so as to generate the right expectations in terms of revenues. We need to know that sometimes we will have losses, and that the losses will outweigh the gains. So we need to consider these criteria that I mentioned to meet supply and demand. We have many more questions, but unfortunately, we have to be very concise and respect the times of this platform. We will send you the questions that we have received, and then we will work out a way to send the answers. I hope that you have all profited from these presentations, and of course we are available to you for any questions you might have. Thank you.